Okay. Ugh. I heard myself. I had to mute the stream. Ugh. I heard myself go, okay. You ready?
Yeah.
You sure?
The QAnon shaman got 41 months.
Yeah, I saw that. I did see that. Yes, absolutely. Hello and welcome to Learning the Law, a podcast about all things legal with a focus on current events, where we try to teach you things in an hour. My name is Ashley, aka Phoenix Nymphy, and my co-host, who is the man of the hour, my husband, Ron. This podcast is purely educational and should not be taken as legal advice. This podcast does not create an attorney-client relationship. This podcast is based on his interpretation of relevant law. Any opinions expressed are the opinions of the individuals making them and do not reflect the opinions of any firm, company, or other individuals. Ron is a licensed practicing attorney in the state of California.
Yes, I am. And have been since September of 99.
This week, the podcast is sponsored by Lawyer.com with 10 plus years of matching experience and technology development. Lawyer.com is proud to make thousands of lawyer connections each week. Lawyer.com connects users nationwide with lawyers in all areas of law. Please use our referral link to help you out and it helps out the podcast to find yourself. Okay. Just use our referral link. You'll help out the podcast and it'll help yourself. Yeah, we're just gonna move on from that. That was a terrible intro. I apologize. So we do have a couple of announcements, and then we're just gonna jump right into Roe v. Wade. So we have started going live on TikTok. Sunday was our first time doing this, and we actually got quite a few people coming in and asking us questions. So we're going to start doing lives on TikTok at least once a week, usually going to be Sundays, might have a couple more during the week. So keep an eye out on that. That's going to be over on my TikTok, which is Phoenix Nymphy. And I'm actually in the process of possibly doing a live with another attorney who does really great work on TikTok as far as educating people. And so I'm very, very excited about that. Very, very excited about all of the things coming up. I've been working on new artwork for the podcast this week that I'm going to unveil at the beginning of next year. So very excited about that. And one final note. This is the last podcast for 2 weeks, and then we will come back and have two podcasts in December. Yeah, the 14th. So we're going on vacation. So this will be the final podcast this week before we go on vacation. And then we will be off for 2 weeks to make sure that we have time. You know, we're not stressed or anything like that. And then we'll be back on the 14th of December. And then the 21st will be our final podcast episode for the year. And then we will be back in January. I don't have the actual date for that yet, but it will probably be mid-January because I would like a proper month to prepare and get everything situated and ready for the new year, because we've got a lot of exciting things that are coming out next year. I'd like to, it'll give me time to get the Patreon set up. It'll give me time to just kind of fine tune graphics and stuff like that. So thank you to everyone who is following us. Thank you to everyone on TikTok. That seems to be where our content is exploding. So without you, we would not be here. So thank you so much for listening. We really appreciate it. And now we're going to jump into Roe v. Wade.
Okay. As you recall, hopefully, we got through the history of abortion through the British common law. And that takes us to the American law and the history in America.
If you are following along with us, we will be on paragraph 45, and the links to all of this stuff is in our show notes, which is over on twolazydogs.sites/learningthelaw.
Yeah, and you will see up until the mid 1800s that the English common law was in effect in all but just a couple of the states in the US. So basically, an abortion before the quickening was fine, but after the quickening, there was some criminal penalties for it. And then
Which, as a
Connecticut,
reminder, the quickening is they called the quickening about 16 weeks, which is going to be about into your second trimester.
right, and the quickening was when you could first feel the baby move.
Yes.
Okay. So the first state to enact abortion legislation in 1821 was Connecticut. And basically, it was called the Ellenborough's Act, and it related that a woman quick with child.
I'm sorry. That is
Yep.
Lord Ellenborough's Act.
What did I say?
You just said Ellenborough?
Oh,
There's a
well,
Lord in front of that Ellenborough.
yeah, okay. You're right. Um, so death penalty was not imposed, but it also used quickening. So an abortion after quickening was made a crime. And uh, before quickening was only made a crime in that state in 1860.
So it was a crime to have abortion in the year 1860.
Yeah. And basically what you'll
Wait,
find,
okay, hold up. They adopted this law in 1821,
correct,
but then like 1 year out of all of after adopting that, if you got an abortion at all, it was a
40,
crime.
basically 40 years after that.
Wow. Okay. But it was just enacted for 1 year. It was just a crime for 1 year.
No.
Okay, what is
It was adopted in 1821.
Yes.
So, and that basically put into law what was the general common law.
Right.
Okay. And then 39 years later in 1860, they basically made all abortions illegal.
Oh, and then after 1860, so 1860 is when it changed
Yeah,
to be banned completely.
correct.
Okay. All right. Sorry, I was misunderstanding that. Thank you for clarifying that.
Okay. And then in 1828, New York enacted legislation that was basically to serve as a model for the early anti-abortion statutes. First, it barred destruction of an unquickened fetus as well as a quick fetus. It made the unquickened fetus a misdemeanor, but the quick fetus a second-degree manslaughter.
So basically, before 16 weeks, it was a misdemeanor, but after 16 weeks, it was manslaughter.
Right.
Okay.
So misdemeanors back then, you did get thrown in jail generally because that's just the way they were for a few months. And then, second degree manslaughter, it would be years.
Right.
And secondly, it incorporated a concept of a therapeutic abortion by perverting.
What is that word?
I apparently come up with new words and wrong words all the time, but providing that an abortion was excused if it shall have been necessary to preserve the life of the mother,
So there
or
is
shall
so they put an exception to the law.
or shall have been advised by 2 physicians to be necessary for such purpose. So basically, you had to have 2 doctors that said it was medically necessary.
Okay. And keep in mind, as stated in previous podcast, in the last podcast and the podcast before, up until this happened, abortion was a common practice across the board, everywhere.
Yeah.
Before
And
they started putting these laws into place abortion was a common practice. So 1860 is really not that long ago.
No, it's 150 years.
Yeah.
So, and basically, what you then had was 1860 was also the year before the start of the Civil War, and it wasn't until after the Civil War that legislation in the states began to replace the common law, and then most of the states, because in 1840, for example, when Texas came into the U.S., um, that might have been, they may come in a little earlier, but 1840, there's only 8 states that had uh, laws dealing with abortion itself. Otherwise, it was just the English common law.
Right,
And
because at this point you had the colonies, the first colonies, and then uh everything else was territories at this point. Like, you don't have a whole lot of states right now in the 1860s. It's mostly the southern states, Georgia, Alabama. I think Florida was a state at the time.
probably
Um,
California was.
but everything in the middle was still pretty much territory. I don't know if Oklahoma, I don't I don't have the dates. I don't keep up with the dates of when all of the states were created states. But we didn't have the 51 states that we have now. And I say 51
50.
because Puerto Rico is a state.
Well, currently it's a territory.
It's a state. Anyway,
It's a state when
that
they say it's a state.
it's a state that is not taken care of. Anyway, I will digress. We will move along. That's a completely different subject. Anyway,
Okay. So, basically, after the Civil War, you get all these laws put on the books, as opposed to common law, which was just handed down from court case to court case. And most of the laws that were put in after the Civil War still had the quickening as a for lack of a better term, a deadline. Before quickening, it was they were pretty lenient laws, fines, minor misdemeanors. After quickening, manslaughter. I don't know if any of them were murder, but I wouldn't have doubted somewhere along the line. And usually, most of the statutes had an exception for one or more physicians to determine that it was necessary to save the mother's life. And then gradually, as you go from the 19th century,
I'm curious. They don't actually talk about why. They don't talk about what. I'm curious what the influence was that caused this to be a thing. I'm pretty confident I know, but I do find that interesting that they don't put. Granted, this is from the Supreme Court, but would they? Well, I guess they wouldn't put the influences in there, would they? They would just state when the dates and when this happened. Because, I mean, right now we're going over the history of abortion that's in this Supreme Court not docket, but document. But what is the influence that caused these changes? And that's where we'd have to go to a history book for, I believe.
yes. Although
I'm confident I know
you
what
can
this.
guess.
Yeah,
You can give your opinion. I mean,
my opinion is it was Puritan culture, and it was the equivalent of the current GOP pushing for it. It was Puritans, like, I mean, especially since it started in 1860, I could definitely see the Christian Southern states wanting to keep every child because they need bodies.
Oh, as a side note, the Union needed bodies too because that's how they actually won the war.
Well, um, so anyway, that's my opinion on that. I would have to go look up, a history book to get confirmation or not,
Okay, I can't say you're right. I can't say you're wrong.
no. But I have a
Um,
feeling the same people that are pushing for it now were the same people pushing for it back then. Because they're
I,
also the same
no,
people who were like, school marms can't be married. Like, you can't be a teacher and be married, which I always felt was weird.
well, yeah, that was true in some areas back in the day as well.
Anyway,
But generally, as you go from the 1800s into the 1900s and 1950s, a large majority of the jurisdictions had outright banned abortion. They got rid of the quickening distinction.
mm-hmm.
There were some exceptions, Alabama, DC, and there were some other states that permitted, quote, not unlawfully performed, which
And
leaves interpretation. It was very vague, you know?
and this absolutely is an influence from the uh alt-right Christian whatever racist bigots, because what have we said before? Abortions disproportionately affect marginalized communities, so it is absolutely racist in nature.
Generally speaking, yes.
No, not generally. It is. It is. Anyway, continue.
As they're writing this in 1973, they say, in the past several years, however, a trend towards liberalization of abortion statutes has resulted in adoption by about one third of the states of less stringent laws. So the pendulum at the beginning of the country quickening deadline, and then that pendulum swung into total outright banning, and then the pendulum started swinging back again. And they sum it up, they say it is in 47. It's apparent that at common law, at the time of the adoption of our Constitution and throughout the major portion of the 19th century, abortion was viewed with less disfavor than under most American statutes currently in effect. Phrasing it,
Meaning,
phrasing it in another way, a woman enjoyed a substantially broader right to terminate a pregnancy than she does in most states today,
right.
at least with respect to the early stage of pregnancy, and very possibly without such a limitation.
And a lot of these changes started happening during what, the civil rights movement,
Yeah, the 60s.
60s and 70s, when
Yep.
women started burning their bras and feminism was becoming a lot more prominent. And 100 years, 100 years to get that pendulum to swing a little bit more left so
Yeah,
that women have rights to their own body.
I believe this was the same time they came out with the birth control pill.
Oh,
Just as a note, I believe it was in the 70s,
I can look
maybe
that up
late
real quick while
60s.
you're still reading.
Okay. So you were asking about influence. And we'll jump to, well, we don't jump. We'll go to paragraph 48 and
1960.
there you go. Um, the the position of the American Medical Association is what brought about a very large part of the anti-abortion mood prevalent. And you can see in paragraph 49, the AMA Committee on Criminal Abortion was appointed in May 1857. So the AMA came out and said that um, abortion with its view to its general suppression. It deplored abortion and its frequency as it listed 3 causes of this general demoralization. And demoralization in this context is basically a degrading of the moral fiber of the country.
Okay. But in the 1850s, doctors were only men. Very rare were they women. So of
That's
course
correct.
men would say that. Of course they would. I just find it funny, find it interesting that men are the ones making these decisions when they don't know anything about our privates. Look, I'm going to be real with y'all right now. I am in the middle of cramping very heavily. I started, and since the surgery, this period is really, really, really bad. No nuance November. This is why we have abortion bans, because men want to control our baby boxes, and they have no clue what we go through. Okay, I'm done for now.
Okay. So getting back to the AMA, the first of their 3 causes was
demoralization, my ass.
What they said was a widespread popular ignorance of the true character of the crime, a belief even among mothers themselves, and I'm quoting this out of paragraph 50, that the fetus is not alive till after the period of quickening. So you have the AMA coming out and saying that before quickening, the fetus is alive.
Which has been disproven by medical professionals now in science. Like, medical professionals do not agree with this assessment. Just FYI, that is not true. But this shows you exactly how men control women. Specifically, marginalized women, women of color. Continue.
Okay. You have then in paragraph 51 the second of their causes, and it says the second of the agents alluded to is the fact that the profession themselves are frequently supposed careless of fetal life.
What does that even mean?
So you have the AMA saying that doctors are wrong to
Is
perform
this
abortions.
even created by, like, are there even doctors on this board?
Usually the AMA was doctors, and I don't know what the
because they're now calling out their own people, saying that their own people are wrong. Like, is it just me, or does this sound very familiar?
What do you mean?
Anti-vax nurses. It just sounds very familiar. Like, okay.
Except a single anti-vax nurse is not commenting on the profession as a whole.
No, and the board is now starting to go after anti-vax nurses. Just FYI, if you are a nurse and you are anti-vax, you might lose your job. So, and honestly, you should.
Yeah, if I was in the hospital, I'd want a nurse that actually cared about my health. But
yeah, I'd like a nurse who actually believes in science and, you know.
And getting back, paragraph 52, they have the third reason is the frightful extent of this crime is to be found in the grave defects of our laws, both common and statute, as regards to the independence and actual existence of the child before birth as a living being.
That is the same excuse that is used to this day by pro-lifers.
Yeah. It is the belief that life begins at conception.
But it doesn't.
Scientifically, no.
Because you have to allow the cells and everything to form. Life begins at first breath. Even for, I'm going to continue repeating this because I need people to understand. Even in the Bible, Jesus himself says life begins at first breath. And one of the things that people like to refer to is in Psalms. There's a psalm where he's talking about I thought of you in the womb. That doesn't mean you're alive. Like the way the teachings are in Christianity, God knows and has known everything that would ever exist. So of course he knows about you in the womb and before you even existed in the womb and before you existed out of the womb. That doesn't mean you're alive. That means he understood your soul existed, right? That means they understood your soul existed. So this is not a religious podcast, but that's my 2 cents when it comes to that argument with Christians. So continue on.
Okay. Then in paragraph 54, you have another report from this committee in 1871 that ended with the observation, quote, "We had to deal with human life. In a matter of less importance, we could entertain no compromise. An honest judge on the bench would call things by their proper name. We could do no less." And it pro-offered resolutions recommending, among other things, that it be unlawful and unprofessional for any physician to induce abortion or premature labor without the concurrent opinion of at least one respectable consulting physician, and then
Meaning a
always
physician that they think that thinks like them.
with a view to the safety of the child, if that is possible. And calling, quote, "the attention of the clergy of all denominations to the perverted views of morality entertained by a large class of females, I and men also, on this important question."
What? You're bringing in religion? You're bringing
So the
religion into
yeah,
this?
AMA is bringing in religion.
That's not your job.
So then you had no further formal AMA action until 1967, when the Committee on Human Reproduction urged the adoption of a stated policy of opposition to induced abortion, except when there was, quote, "documented medical evidence of a threat to the health or life of the mother, or that the child may be born with incapacitating physical deformity or mental deficiency, or that a pregnancy resulting from legally established statutory or forcible rape or incest may constitute a threat to the mental or physical health of the patient."
I have a problem with that. Legally established means that they have proven that they were raped. I'm sorry, but as a sexual assault survivor and a rape survivor, none of my abusers were ever legally charged because nobody cares. They don't care. The government doesn't care. When I came out and told people, I was shunned and I was told that I was a drama queen. So that is nearly impossible to prove that you were raped or assaulted. So that right there is messed up. Because you can't always prove that you were raped legally, even though you were. So unless, I guess the Texas state pulled that out, had to pull that from this because their law, their heartbeat law thing, heartbeat act, whatever they call it, says that exact same thing. You have to establish that you were raped. And it's like, you don't understand how that works. You don't believe us when we tell you. So how can we get it legally established?
Right. And it was even reported less frequently back then than it is now.
Yes, because back then it wasn't illegal to rape your wife.
That is true. I believe it. I don't know if that's true in all 50 states, but I know a vast majority of them, that's true.
A vast majority of states did not change that law until like 80s, 90s. Yeah. That's a law that just recently changed in a lot of states.
And then, starting paragraph 57, you had another association, the American Public Health Association, come out with its executive board and its standards for abortion services, and they had 5 in number. 1, rapid and simple abortion referral must be readily available through state and local public health departments, medical societies, or other nonprofit organizations.
i.e., Planned Parenthood.
Correct. 2, an important function of counseling should be to simplify and expedite the provision of abortion services. It should not delay the obtaining of these services.
Oh, man, that is so important. Because a lot of people, when they do get counseling, and I do think that that is something you should get counseling for, but I agree, it should not be a delay. Like, if you really feel strongly about it, yeah.
3, psychiatric consultation should not be mandatory. As in the case of other specialized medical services, psychiatric consultation should be sought for definite indications and not on a routine basis.
Well, they also were just expanding into mental health at that time. I recommend counseling just because you're dealing with a lot mentally, period.
Yeah.
Whether or not you go through with it, you still should seek counseling going through something like that.
Number 4, a wide range of individuals from appropriately trained sympathetic volunteers to highly skilled physicians may qualify as abortion counselors. And then lastly,
Hush.
contraception and or sterilization should be discussed with each abortion patient. And so that's in direct opposition to the American Medical Association position.
Is the American Medical Association still around, or is it now
Oh, yeah.
Okay. So
I don't know that they've said anything since 1967, but we're reading from the opinion from 1973. So something tells me they have. It's been 50 years or so, but I don't know what they have said or what position the AMA takes.
the AMA is funded by the drug industry.
No doubt. Big Pharma, you could say Big Pharma has a lot of money wrapped up in the day after pill.
Yeah. Yeah. According to quick Google searches, the AMA is funded by Big Pharma. So,
Big Pharma will be for whatever makes him the most money.
yeah, exactly. So, they're not really a reliable source.
No, but back in the 1850s when all of their influence started,
Right.
there really wasn't a big pharma at that time.
No, but there were people in Congress who wanted to make money.
Oh yeah, people in Congress always want to make money. That's why they
Right.
come out millionaires.
See, and that's what strikes me. That's why, like, when I read that, when we first read that, I was like, that just doesn't, something doesn't seem right here. This just doesn't seem, yeah, okay, these are doctors being paid to say that. These are people being paid to say that. They don't care.
And then you got also in that report from the Public Health
Mm-hmm.
Association, you had factors pertinent to the life and health risks associated with abortion were three that were recognized as important. Number one, skill of the doctor. Number two, the environment in which the abortion is performed. And three, the duration of the pregnancy at the time the abortion is performed, as determined by uterine size and confirmed by menstrual history.
Just to let you know, the American Public Health Association was funded by doctors.
Okay, good to know. I did not know that.
Yep.
And they said that a well equipped hospital offers more protection to cope with unforeseen difficulties than an office or clinic without such resources. Which, that's true. That's where you get the term the back alley abortion.
Mm-hmm.
Um, the factor of gestational age is of overriding importance. Thus, they recommended that abortion in the second trimester and early abortions in the presence of existing medical complications be performed in hospitals as inpatient procedures. For pregnancies in the first trimester, abortion in the hospital with or without overnight stay is probably the safest practice. However, an abortion in an extramural facility, however, is an acceptable alternative providing arrangement exists in advance to admit patients promptly if unforeseen complications develop. And it gave standards for abortion facility. So that's where the Public Health Administration
So the Public Health
position was.
Administration, the difference between the Public Health Administration and the Medical Association is basically right wing versus left wing.
Yeah, pretty much.
I mean, that honestly, if you just look at Wikipedia, the AMA is a professional association and lobbying group. That's what they're titled as. They are a lobbying group, and they are associated with several big pharmacies now. And they have a rather large, they spent $18 million on lobbying. I think it said in 2018 or something like that. And the American Public Health Association is a little bit different. It was founded by a group of physicians, and it's an organization that champions, they describe themselves as an organization that champions the health of all people and all communities. So, yeah, it's leftist versus right. That's basically what it is. So that's the politics that is the politics that are at play in this particular case. And that's knowledge that you need to know. That's what you need to have. You need to know like what the AMA's goals are and what the health association's goals are when making these statements.
Right. And then for the last association's position, you have the ABA, the American Bar Association.
Why did they bring in the ABA?
Because they themselves are, came from being lawyers. And in 1972, the ABA approved the Uniform Abortion Act. And if you go down to to footnote 40, it gives what the Uniform Abortion Act is.
Okay, what is that?
Okay. One, it defines abortion as a termination of a human pregnancy with an intention other than to produce a live birth or remove a dead fetus.
Okay.
And two, or B, an abortion may be performed in this state. And I have to say this state because they come out with these uniform acts and then states vote on them from time to time.
Oh,
So
so it's like a
this is
insert
a
name
generic,
here. Yeah.
generic template.
I state your name kind of situation.
Exactly. An abortion may be performed in this state only if it is performed, one, by a physician licensed to practice medicine, or by a physician practicing medicine in the employ of the government of the United States.
Okay.
Da 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 da. Number two, within 20 weeks after the commencement of the pregnancy, or after 20 weeks only if the physician has reasonable cause to believe there is a substantial risk that continuance of the pregnancy would endanger the life of the mother or would gravely impair the physical or mental health of the mother.
All of this, when was this written? In the 60s?
1972.
Okay. And when was Roe v. Wade?
1973.
Okay, so this was written the year before this case.
Yes.
Was it written because of this case or just...
It may have been because, this trickles up.
Right.
So it took a little bit to get to the Supreme Court in 73.
Okay. Yeah.
I don't know that it was a direct result of this case coming through the courts.
Right.
But, the pendulum was swinging back. So maybe the ABA thought that, they need to come up with a template for states to follow.
Gotcha.
Okay. It also provided that the child, one for the child be born with a graver physical mental defect. So after 20 weeks, abortion was fine. And that if the abortion resulted from rape or incest or illicit intercourse with a girl under the age of 16 years. Now, that does not say what the law said earlier about legally provable,
Right.
Okay. Section 2, any person who performs or procures an abortion other than authorized by this act is guilty of a felony, and upon conviction thereof may be sentenced to pay a fine not exceeding $1,000 or imprisonment in the state penitentiary not exceeding 5 years or both.
$1,000 ain't nothing to a doctor, though.
No, $1,000 is a lot of money to somebody who procures it.
Oh, well, yeah, it does say procure. Yeah, that's true.
Although 5 years is a long time for a doctor to go to jail.
Yeah.
And then this act shall be construed to effectuate its general purpose to make uniform the law with respect to the subject of this act among those states that enact it. So part of the purpose of this act is to get a uniform abortion law equivalent among all the states.
Gotcha.
Doesn't always happen with their uniform templates.
Right.
And then basically it just says if any if any provision of this act or application is held invalid, the invalidity does not affect other provisions of the act.
Meaning?
If Section 3 is held to be invalid, illegal, unconstitutional, all the other sections can still be in effect.
Oh, okay.
Yeah. And that's basically that law. Their uniform law.
Now, did they stick with that law after Roe v. Wade, or will we find that out in the...
That was just a proposed law.
Oh, that's just a proposed thing. Okay.
Yeah, that's just a template.
Okay.
But
so basically the American Medical,
Yeah, you have
not the
the
AMA, but the other one.
ABA, American Bar Association,
No, the
or the Public
APHA,
Health.
the
Yeah,
Public Health Association. That's why they pulled in the Bar Association to come up with something, is what it sounds like.
yeah. It sounds like they pulled in all three to get some kind of
Uniformity.
and compromise going.
Yeah. Smart. Smart move.
Okay, and so that was paragraph 68,
Yep.
and we come to paragraph 69, where they're still going into a history lesson.
I find it interesting that they put all of this history in here, which is good. Like, because I'm learning a ton.
As am I. um, paragraph 69 says 3 reasons have been advanced to explain historically the enactment of criminal abortion laws in the 19th century and to justify their continued existence. It has been argued occasionally that these laws were the product of a Victorian social concern to discourage illicit sexual conduct. However, Texas, however, does not advance this justification in the present case, and it appears that no court or commentator has taken this argument seriously.
Right, because their minds are also still in that Victorian social concern.
The appellants and Amici contend, moreover, that this is not a proper state purpose at all, and suggest that, if it were, the Texas statutes are overbroad in protecting it since the law fails to distinguish between married and unmarried mothers.
What?
So there we go.
Also, what does Amici contend mean?
Amici is observers and people that file amicus briefs.
Okay, what's an amicus brief?
That's a friend of the court brief that some organizations or lobbyists will file on a Supreme Court case to give the Supreme Court more information that they think they would need.
Gotcha. So what does this basically say? That Texas is stuck in the Victorian society and that they are overbroad?
No. What it's saying is that the argument that there's such laws to stop illicit sexual conduct is BS, and Texas does not even make that argument.
Oh, you mean like the argument? Okay.
But if Texas did, such an argument is overbroad because it fails to distinguish between married and unmarried mothers.
I'm still confused.
Illicit sexual conduct. Married is good sex, unwed is bad sex.
Oh, okay. So this paragraph kind of makes me think of what Abbott said when he wrote the act into place, and he's like, well, we're just going to stop all rapes. How are you going to do that? Like, this is what that sounds like to me.
As a side note, the way Texas is going to do that is not process any of their rape kits, and therefore they can't prosecute rapists. If you don't find someone guilty of rape, then there is no rapist.
That's your opinion.
Well, I mean, that's just the way Texas seems to be.
Interesting.
No one's going to get rid of rapists.
No, you know. No.
Even if it was a capital crime, you wouldn't get rid of them.
Not until we have a society that understands that misogyny is bad.
And then you'd still have rapists.
Yeah. It's a power dynamic. It has nothing to do with... Anyway, we're getting off topic.
The second reason that these criminal abortion laws have been around is the concern with abortion as a medical procedure. When most of the first criminal abortion laws were passed, the procedure was a hazardous one. And this is particularly true to the development of antisepsis. Antisepsis techniques, of course, were based on discoveries by Lister, Pasteur, and others first announced in 1867, but not generally accepted and employed until about turn of the century. So abortion mortality was high, and what that means is deadly infections were very common
Yeah,
in 18th century abortions.
because they didn't.
And even
Yeah,
though in 1867 you had a way to fight infections, most people didn't believe or follow it.
yeah. You want to know? Fun fact. Fun fact. One of the reasons why so many mothers died back in the day is because they didn't believe in washing their hands. And doctors who used to deliver babies also cut up dead bodies. And so they would cut up the dead bodies and then not wash their hands and go deliver a baby. And that mom would die because they didn't believe in washing their hands.
You could call
Because,
them the anti-vaxxers of their day.
yeah. Uh, so that's why a lot of the mortality rate for mothers is exceptionally high back then because of that. Because they'd get infected and die.
Yeah. So, but modern techniques, such as dilation and curettage, were not nearly so safe as they are today.
Right.
And thus, it has been argued that a state's real concern in enacting criminal abortion law was to protect the pregnant woman, that is, to restrain her from submitting to a procedure that placed her life in serious jeopardy.
Back in the day, but not
Back in the day,
in
but
the
not now.
70s. Like, we were, I mean, yeah. Like, that's
But
not a valid excuse anymore.
back in the 60s and 70s, you still had back alley abortions where women were
Right.
dying.
Because it was illegal to have an abortion and people didn't want to be pregnant. So they were
That's the
forced.
Yeah, that was the major conflict, you could say, in Dirty Dancing.
Yeah. They were forced to go to back alley abortionist because of the fact that abortion was illegal.
Yeah. And that's the Supreme Court says modern medical techniques have altered the situation.
Right. So there's no
Appellants and
excuse why we can't.
appellants and various amicus briefs refer to medical data indication that abortion in early pregnancy, that is prior to the end of the first trimester, although not without its risk, is now relatively safe.
And it's even safer now than it was in the 60s and 70s.
Yeah. Mortality rates for women undergoing early abortions where the procedure is legal appear to be as low or lower than rates for normal childbirth.
What?
Consequently, any interest of the state in protecting the woman from an inherently hazardous procedure, except when it would be equally dangerous for her to forego it, has largely disappeared.
Go
So this
figure.
Yeah, the state has no longer an interest in protecting a woman from deadly infections, basically. Of course, important state interests in the areas of health and medical standards do remain. The state has a legitimate interest in seeing to it that abortion, like any other medical procedure, is performed under circumstances that ensure maximum safety for the patient.
That's all anybody wants.
This interest obviously extends at least to the performing physician and his staff, to the facilities involved, to the availability of aftercare, and to adequate provision for any complication or emergency that might arise. The prevalence of high mortality rates at illegal abortion mills strengthens rather than weakens the state's interest in regulating the conditions under which abortions are performed.
What? You don't say.
Moreover, the risk to the woman increases as her pregnancy continues. Thus, the state retains a definite interest in protecting the woman's own health and safety when an abortion is performed at a late stage of pregnancy.
Which,
You
again,
can
I reiterate, very rarely will people want to have a late stage abortion. Those are very rare
Now,
occasions.
now, in hindsight, you can see how the court is starting to develop this 3 trimester guideline.
Yes. Yeah. Yeah. We're actually coming up on
Okay.
an hour.
Okay, let me
This
go
hour
through.
went by so fast.
Let me go through paragraph 73, because I want to give the third reason.
Yeah,
Before
that'll
we
be the
take
third reason. Then
yeah,
we'll, yeah.
right. The third reason is the state's interest. Some phrase it in terms of duty in protecting prenatal life. Some of the argument for this justification rests on the theory that a new human life is present from the moment of conception. The state's interest and general obligation to protect life then extends, it is argued, to prenatal life. Only when the life of the pregnant mother herself is at stake, balanced against the life she carries within her, should the interest of the embryo or fetus not prevail. Logically, of course, a legitimate state interest in this area need not stand or fall on acceptance of the belief that life begins at conception or some other point prior to live birth. In assessing the state's interest, recognition may be given to the less rigid claim that as long as at least potential life is involved, the state may assert interest beyond the protection of the pregnant woman alone.
Dang. It was so good. And then crap. I like the state interest in this area need not stand or fall on acceptance of belief that life begins at conception or at some other point prior to live birth. Leave it. That's it. That's all you needed to say. Y'all didn't need to continue because the rest of it doesn't matter whether or not the state believes, because this is not, like, it doesn't matter. And I will say that I have learned recently that abortion rights have been completely removed from, oh my God, I forget. I believe it's Poland. Yes. So a woman in Poland just died. She was 30 years old. She died of septic shock in her 22nd week of pregnancy because the baby died. But the doctors would not perform an abortion, and they forced her to carry it, and she died. A woman in Ireland also died. I remember this story years ago.
Yeah.
For the same reason, because she was in a very Catholic area of Ireland, and so nobody would perform the abortion. And I would like to note that having a child, like the argument of having an abortion is very selfish. Well, guess what? Having a child is also very selfish. Bringing a person into the world who didn't choose to be brought into this world is an extremely selfish act. Especially with the fact that they can't do anything in the beginning of their life. So you can't use that excuse of having an abortion is a selfish thing, because having a child is too.
And I will say that the uniform law that the ABA proposed, removing a dead fetus, is not considered an abortion.
I would not think it is.
I wouldn't think it is either. I would think it would be medically necessary.
Yeah. Yeah. Women are literally dying because of the fact that they don't get to choose for themselves. Literally dying. And again, we're just in the history of this. It's not just all about abortion. That's a reminder. It's not all about abortion. And we will get to that. But this is a very large document, and I think it's very important. We think it's very important to go through the whole document and explain. And I think this history is very, very crucial, just based off of what our history is for abortion and what the world's history is for abortion. So we will be back on December 7th, right here, same time.
And December 7th should wrap up.
Yeah, we are getting
Roe
close
v.
to the end. So that should wrap up Roe v. Wade, which if we do wrap up Roe v. Wade, we might just make that our final episode of the year instead of trying to start something.
Well, I would, if we do wrap it up next time, we can do that second podcast on KCV Planned Parenthood, which is the 92 support of Roe v. Wade. So
okay,
I think it's important to know that too.
So that's our plans. Thank you so much, everyone, for hanging out. This hour went by so fast. Like, I had no idea. I just happened to look down. I was like, wait, what time is it? It's an hour. But seriously, thank you so much for listening to the podcast. If you like this podcast, please make sure to like, subscribe, follow, and share in all your favorite places. Don't forget to follow us on Twitter at learningthelaw. You can follow Ron at Necrokijo. That's Necrokijo. And you can follow me at Phoenix Nymphy. You can also find us now streaming on TikTok at Phoenix Nymphy. All of my social medias and all of the content that I create will be under the Phoenix Nymphy name. So if you would like to find our lives and stuff on TikTok, please go follow there. If you have any questions, please tweet, comment, or email us at twolazydogsmedia@gmail.com. This has been a Two Lazy Dogs production.
Thanks, everyone.